thank all of our witnesses for joining us today. Before we begin, I'd like to remind members who have established an email address and distribution list dedicated to circulating exhibits, motions, and other written materials that members might want to offer as part of our hearing today. If you'd like to submit materials, please submit them to Judiciary Docs. That's D-O-C-S, as in doctors, Judiciary Docs at mail.house.gov. We will distribute them to members and staff as quickly as we can. I will now recognize myself for an opening statement. With the authority to enforce this nation's civil rights laws, the Department of Justice's Civil Rights Division is supposed to be the guardian of our most cherished and fundamental rights, the rights to be treated equally, the right to cast a vote in a free and fair election, regardless of race, the right to obtain a job, a home, or an education free from discrimination, and the right to exist in a society where the police respect your constitutional rights and your rights as a human being. So that's a pretty good group of rights to protect. Treated equally, regardless of race, free from discrimination, and exist in a society where the police respect your rights. Over 60 years ago, Congress passed the Civil Rights Act of 1957 when Dwight Eisenhower was president, and as some people we know would say, Dwight Eisenhower was Republican, just like Abraham Lincoln, to protect the voting rights of Black Americans and other minorities. It was the first civil rights law Congress had passed since Reconstruction, though it would later be overshadowed in importance by the Voting Rights Act of 1965 and, of course, the Civil Rights Act of 1964. He represented a start of a reinvigorated effort by the federal government to ensure that all Americans could exercise their right to vote. The Civil Rights Act of 1957 established the Civil Rights Division in Justice. It's important to highlight that the very genesis of the Civil Rights Division was rooted in a renewed federal effort to protect voting rights. The right to vote is the foundation right upon which all other rights I previously described ultimately rest. Voting rights in the 50s were, of course, most in jeopardy in the South. It is why I'm especially concerned about efforts around the country since the Supreme Court's decision in Shelby County versus Holder to prevent Americans from exercising the right to vote. Since Shelby County, we've seen the enactment of various voter ID laws with the purpose and effect of preventing people from voting under the pretext of protecting the integrity of elections. Many of you may remember Shelby County versus Holder and a wonderful dissent written by the late Justice Ruth Bader Ginsburg. These efforts are not without precedent in our country. In the past, literacy tests, grandfather clauses, and poll taxes had been used to silence the voices of Black Americans and other minorities that those in power did not want to hear from. The literacy tests would have failed Albert Einstein. They were impossible to pass for the most brilliant of human beings, because they were designed by some of the less brilliant to make them the predominant voice. Today, we see different methods intended to achieve that same end, such as voter roll purges, which include a removal of voters we know for a fact are qualified, or the requirement of particular forms of voter identification that we know some segments of the population are less likely to possess. Yet, where is the Civil Rights Division? Where is the guardian of our civil rights? It pains me to say that, but despite its righteous history and traditional role, the Civil Rights Division appears under the Trump administration to have abandoned its historical mandate to protect voting rights, more interested in protecting other newfound important rights that sometimes trample on other people's rights. Since the start of this administration, the Civil Rights Division has filed 0 new Voting Rights Act cases till this past May, and none that enforce the rights of Black and Latino voters. It has also abruptly changed positions in several existing voting rights cases, including a case against a racially discriminatory voter ID law in Texas and a challenge to a purge of Ohio's voter rolls. As bad as this is, it is not the only change for the worse we've seen in the Civil Rights Division since the start of the current administration. Under the former Attorney General, Jeff Sessions, the division sought to curtail the use of consent decrees as a tool to reform police departments that engaged in a pattern and practice of unconstitutional conduct, asserting that such decrees reduced the morale among officers. and had the effect of increasing violent crime. Reduced the morale among officers. Despite the new wave of protests against racial injustice and police violence that began after the murder of George Floyd, these policies have continued under Attorney General Bill Barr. One of the purposes of justice is to bring peace to communities, yet Attorney General Barr has only intensified the divisions and refused to allow the Civil Rights Division to perform what its function is supposed to be. Indeed, despite a request from leading civil rights groups and calls from the community, Attorney General Barr has so far refused to allow DOJ to open a pattern or practice investigation into systemic racial discrimination by the Minneapolis Police Department following the killing of George Floyd. Perhaps thinking that the institution of law and order on the streets from Washington was a better way to achieve that and to boost the morale of the police. The Civil Rights Division has become a twisted shadow of its former self in Bill Barr's dystopian Justice Department and under this administration. The division must answer for its inaction or, in some cases, its active opposition to civil rights enforcement. With the guidance of our witnesses today, it must chart a new course going forward. Now, today we have a special guest, or the absence of a special guest. Normally at a hearing like this, the Assistant Attorney General for Civil Rights would appear before us to testify about the work of the Civil Rights Division, custom and norms. The Assistant Attorney General for Civil Rights have typically appeared before this subcommittee for these hearings. In July, when Attorney General Bill Barr acquiesced to appear before this committee after refusing to do so over a year earlier, when he chickened out because he didn't want to have two attorneys, Mr. Eisen and his cohort, question him, I asked, at the insistence of my counsel on the committee, I asked Mr. Barr to send Assistant Attorney General Eric Dryban and ask him to commit to sending him to testify before this hearing. He replied in a condescending tone, "I'll talk to him about it," and turned his head aside. And I asked him again, I said, "Will you get him to appear before this committee?" And once again, in that same condescending tone, he turned away and said, "I'll talk to him about it." Well, I don't know what he said to him, but Mr. Dryban's not here. There's a seat for him, just as there was a seat for Mr. Barr in 2019, an unoccupied seat, showing the disdain they have for this committee, for the legislative process, for the House of Representatives. And apparently they think it's the unitary president is not just the president who controls the entire executive, but controls the entire government. On August 28th, the committee sent a formal invitation to Assistant Attorney General Dryban to testify today. And on Monday, in the latest pattern of a long-standing pattern of complete obstruction, the Justice Department informed us that Mr. Dryban would not be appearing for this hearing. Worse yet, the excuse that the department provided was about as immature and unsophisticated as saying, "The dog ate my homework." Evidently, the department feels we were too rough on Attorney General Barr. We hurt his feelings. We didn't treat him with the respect that previous attorney generals deserved when he appeared before us, and is therefore refusing to send other officials to testify before this committee. That dog won't hunt. Under our system of checks and balances, the Congress has the right and the obligation to conduct vigorous oversight of the executive branch, and the executive branch has the obligation to be responsive to Congress's legitimate oversight inquiries, even those inquiries which may be pointed in tone. That's why Congress is Article 1. The Founding Fathers intended Congress as Article 1 to be the top branch, the people's representatives. The department's broad refusal to cooperate with the committee's legitimate request not only undermines our nation's constitutional system, a system in which no branch is above scrutiny, but also does a disservice to the public. The American people who pay for the Justice Department and who the department is supposed to serve have a right to know what the Civil Rights Division has been doing and to assess the quality of its performance. particularly as we approach an election in which the people have a chance to render their judgment about such a performance. By keeping this subcommittee in the dark, the department keeps the public in the dark. We know why they keep us in the dark, because they don't want to tell us what they've not done. This is totally unacceptable, and I call upon the department once again, and I know calling upon the vacant seat, calling upon the department, asking Bill Barr to do anything is fruitless. But I will call once again, as my able and learned and wise counsel suggested, asking Mr. Barr if he would ask Mr. Dryban to come before this committee, knowing that he would not do it. And I wasted 30 seconds of my time, but we got him on the record to say he would discuss it. And when I saw his condescending tone after I watched the film of that, I realized it was wise that I didn't ask him questions, and I attacked him for destroying the First Amendment at Lafayette Square and sending the troops in, because he wasn't going to answer any questions appropriately. His not sending his representative here and the people's representative is unacceptable, and I will call upon the department to make Assistant Attorney General Dryban available promptly to testify about the civil rights work of his committee. It's now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.